Good afternoon, everyone. My name is Meggie Cruser. I am the Senior Notes and Comments Editor for the South Carolina Law Review. And today I have the honor of introducing Chief Justice Jean Toal. I've only been given about a minute, so I definitely won't be able to do her justice, but I want to say just a couple of things before she comes up. Justice Toal received her BA degree in philosophy from Agnes Scott College and her JD from right here at the University of South Carolina School of Law. While she was here, she served as managing editor, leading articles editor, and book review editor of the South Carolina Law Review. She's also a member of the Order of the Coif, Mortar Board, and Phi Beta Kappa. In 1988, Justice Toal became the first woman to serve as a justice of the South Carolina Supreme Court, and she served a total of 27 years on the Supreme Court and was installed as Chief Justice in March of 2000. Along with many other accomplishments, Justice Toal served in the South Carolina House of Representatives for 13 years, and she still serves now as a senior active judge in the Circuit Court and the South Carolina Supreme Court. Please join me in welcoming Justice Toal.
Thanks so much, Megan, and to you law reviewers, what a grand opportunity to be back home. I loved my years on the Law Review. My husband and I courted and married our junior year and were editor and managing editor our senior year. But the Law Review had such a major influence on our practice, not to mention our personal relationship. I want to put in a word for the next couple of minutes on the status of the workhorse of the American system of justice, and that's the state court system. 93% of all litigation in the United States is administered in state courts. If you were to take the entire book of business of the federal system, all the district courts, all the magistrates, all the courts of appeal, the United States Supreme Court, and the various other specialty courts, and put all that book of business together for a year, it would not take up a month of the state court docket in the state of New York. So that gives you some idea of the breadth and depth of the responsibilities that are faced by state court judges and the importance of judicial independence in that giver of so much of the rule of law and its maintenance in this country. The system that is employed by South Carolina to choose its judges is one used by only two states in the Union, South Carolina and Virginia. But the method of selection by a joint assembly of the House of Representatives and the Senate of South Carolina was the method used to select state officers, United States senators, and just about every other official you could think of in the beginning of this country. Some people were horrified when I would tell them as Chief Justice that that's how we did it in South Carolina. Oh, Gene, you couldn't possibly have any independence. You have to go and beg to those legislators. When I was there as a young member of the House of Representatives in a year when there were 52 new members, because it was the first year of single-member districts, we made a lot of difference about a lot of things, and one of them was judicial selection. It took us a while, but under our watch, we introduced a concept to the joint election by the legislature of judges, which was screening of judges. It was the first time that candidates were forced to reveal their financial information, to be vetted by a panel, to have those hearings in public, and to discuss their qualifications, their background, and their experience. When Sandra Day O'Connor finished her service on the United States Supreme Court, she had several projects that she thought were very important. Civics education was one that she's very well known for, but selection of judges by state courts was her first big project. She came from a state which is like 38 other states, Arizona, where judges are elected by popular election. She thought that was the worst system. Money-driven, driven by anything but the qualifications of the members, she thought, and capable of producing some very dire results when judges made tough decisions. And that's happened all over the country, as we know, from time to time. Justice O'Connor and I traveled around the country. We were good friends, and first in a lot of ways. And we traveled around the country talking about judicial independence and state court selection. And finally, she looked at me one day and she said, "Jean, y'all may have the best system. You got some tweaking to do with that vetting you make, and you ought to include the governor in that a little bit, and perhaps have some other kind of way of involving the nomination process and something more than just people offering." But the idea of a legislative selection as the voice of the people and surrogates for the people rather than popular elections got a lot of appeal to me. So I'll be interested this afternoon to hear the brilliant panels that have been assembled by our students on the Law Review to talk about the various ramifications and the various issues that arise in judicial independence, in real judicial independence. But when you think about those things, don't forget the state courts.